SJC-12594 in the matter of an impounded case.
Ms. Frame, good morning.
Good morning. May it please the court, Kate Frame on behalf of the plaintiff. When attorneys who represent individuals before the Sex Offender Registry Board receive a decision from the board in their inbox, the first thing they look for in that decision is whether their client is going to be posted on the SORB's website. The first thing a client wants to know when they receive a decision from the SORB is, am I going to be posted on the board's website? This is because being posted on the internet and identified worldwide as a dangerous sex offender is the most significant and damaging potential consequence of being classified as a sex offender by the Sex Offender Registry Board. The hearing examiner's determination as to whether this is going to occur is the most critical component of the hearing examiner's decision. It is not a mere technicality, and it can't be an afterthought. And the Sex Offender Registry Law at 178K2B, this court's decision in Moe v. SORB in 2014, and due process all require that before classifying an individual as a level 2, the hearing examiner must determine not only that that individual poses a moderate risk, but also that they pose a degree of dangerousness such that public availability with internet dissemination is necessary. If we begin with the language of the statute in 178K2B, it provides that where the board determines that an offender poses a moderate risk and that the degree of dangerousness is such that public availability is in the interest of public safety.
So if that's the most important component of a level 2, isn't it interwoven into the level 2 finding that you need this dissemination? You seem to be overturning Moe upside down to me, in the sense that that was the whole point of Moe. So I'm not sure how we can reverse engineer Moe to do that now.
Well, I have a different, I guess I disagree with the board's interpretation of Moe. I think that language,
Didn't Moe say that the whole decision was interwoven so that when you added this internet dissemination requirement after the fact, it changed everything?
well, what this court said in Moe actually was that the prospect of internet dissemination may change the hearing examiner's assessment of what classification level is appropriate, because the hearing examiner may determine, regardless of their assessment of dangerousness, they may determine that public availability with internet dissemination is not in the interest of public safety.
Didn't the hearing examiner address internet was necessary for public safety in this particular decision? And I'm not so sure, I don't know if you finished answering Justice Kafka's question.
I did, but I believe that in Moe, and Moe talks about interweaving basically
referring to the classification as a holistic enterprise, right? That level 2, level 3, level 1, all the different elements combined. So to suggest that we need an express finding of each part, or at least the parts you want us to make express findings on, seems to be contradictory to what Moe said.
Well, the hearing examiner is required to make specific and detailed findings about numerous things by both the statute and according to due process principles. 20 years ago in Doe 972, this court said that the hearing examiner is required to make specific, detailed, individualized, and written findings to show that the classification is appropriate. And so a hearing examiner, hearing examiners write a 20 to 25 page decision. The decision in this case was 25 pages long. It doesn't make any sense for the hearing examiner to make specific findings about 38 different factors that support the level, but not to make any finding as to what is really the ultimate conclusion of their case.
As Justice Gassiano just pointed out, the hearing examiner does make a finding regarding the need for internet dissemination here.
Yes, and I think this case, because she does make the finding in this case, and that's rare. If you look in the record at page 12, I think it's 1236 to 1241, there's a lot of data about what findings hearing examiners have been making in level 2 decisions since the law went into effect in July 2013. And it's very rare. I think there was only one other case where the hearing examiner expressly said for level 2 that it was necessary. There may have been 2 others. But essentially, they don't typically even make a finding that public availability is in the interest. So this case is an anomaly, but it illustrates to us, because the hearing examiner made the finding in this case, it illustrates why an implicit finding is not enough, because we're able to see in this case that the findings...
But you want us to rule on a case that's not before us.
No, the findings in this case, Your Honor, were not adequate.
Oh, no, that's a separate issue.
Yes.
You have the due process issue of Moe and whether it needs to be explicit, which it was in this case. But then the separate issue, which I'm really interested in, is the substantial evidence issue and your argument that essentially there was cherry picking by the examiner.
I'll move on to that. But
and if you have
yes.
if you have anything else to add on the Moe issue.
Yes, because I would like to add that I think the findings in this case were not sufficient because she did not find that he poses a dangerousness such that internet dissemination is necessary. In fact, she found that his offenses were not gravely dangerous, and she found that the reason why he needs to be posted on the internet essentially is so that current and future neighbors, essentially, presumably who would otherwise stand undressed or engage in certain acts in their windows with the lights on and the shades up, if they know that my client has a history of exhibitionism, they will not engage in this behavior, which will therefore not cause him to engage in the same behavior toward them.
Counsel, can you refresh my memory, please? The difference between a 1 and a 2 in terms of what obligations are placed on the plaintiff?
Well, for a level 1 has to register with the board annually,
And that's
directly
it?
with the board. They don't have to go to the police. And the only people who know about their offense history are law enforcement, the
Okay.
police.
And then a level 2,
And a level 2, currently, since July 2013, for a level 2, they have to go to the police station. Well, they've always had to go to the police station.
so that's a number
Right.
1. Number 1 has to go to the police station too.
Well,
also.
level 1s register directly with the
Okay.
board.
So they don't go to
Yes,
the police
they
station.
don't go to the
Level
police
2
station.
goes to the police station.
They go to the police station.
And what
yes.
else?
And they are subject to, if someone in their town, for example, or in the town where they work or live, goes to the police station and asks for registration information about level 2s, their information is given out to that person. And additionally, since July 2013, they're subject to internet dissemination.
I don't understand why the hearing officer's finding that internet dissemination was appropriate is inadequate, based on what you just said, the reasons why. I mean, what's wrong with the finding?
Well, she didn't make a finding that that his dangerousness is required internet dissemination. And 178K2B expressly requires the hearing examiner to determine not only risk, but whether the offender poses a degree of dangerousness such that public availability is in the interest of public safety.
Public availability includes internet dissemination.
Yes, and since the law went into effect in July 2013, effectively, as this court found in Moe, this concept of public availability was revised to include this concept of internet dissemination. So now, prior to July 2013, when a hearing examiner decided that someone was a level 2, they had to find that person posed a sufficient danger that the more limited kind of release of registration information that applied to level 2s prior to the law was required. In other words, that if someone in their town goes down to the police station, they can fill out a form, request their information. So there were geographical limits on the release of the information. Since now that the concept of public availability has been expanded to include internet dissemination, The hearing examiner has to find that this much more expansive form of dissemination is warranted by the specific dangerousness, the degree of danger that the offender poses. And even the,
Gets me to where Justice Kafka started out with Mo. I'd ask you maybe from a little bit of a different perspective. So after the change in the law, somebody who was already a level 2 couldn't remain a level 2 without another hearing. It was unconstitutional to retroactively apply that because the board had never made a decision
yes.
about whether or not somebody had to publicly register and their name be available on the internet. So the whole point of the unconstitutionality of the retroactivity was that analysis never occurred. So
Yes.
why doesn't the law after Mo require that that determination be made before you can be a level 2?
I agree, Your Honor. That's exactly why, Mo requires that that determination be made. I mean, it's one of the hearing examiner's ultimate factual findings. It's one of their critical inquiries, if you will. This court held in Doe 380316 that the hearing examiner has to prove its case by, the board has to prove its case by clear and convincing evidence.
I know, but you understand my question is why isn't it just, I guess the word that's been used in the brief and otherwise is interwoven, but based on Mo, they can't find a level 2. And then you've got the 38 of the Superior Court. There can't be a level 2 unless there's a determination that the dangerousness requires publication.
Yes, that's exactly how I read that language on page 615 in Mo. And the court, I believe in that case, indicated that it's likely the most important determination because if it's not there, then the person can't be a level 2. And the court even said, the prospect of internet dissemination may not affect the assessment of dangerousness, but it may affect the assessment of what level classification is appropriate because the hearing examiner might decide that public availability with internet dissemination is not in the interest of public safety. And in this case, again, we can assess the dangerousness findings in this case and see that they're not adequate. This is not an adequate reason to put someone on the internet because their neighbors may engage, some neighbors in the future may engage in behavior that may trigger their behavior.
The argument is whether or not he's appropriately a level 2 based on this evidence, right?
Yes, I'm also making that argument. But I think that, we have to be able to, if the hearing examiner is not required to make any analysis as to why internet dissemination is necessary, then their finding is essentially immune from judicial review.
Can you give me an example, please, of what that analysis would sound like and look like? Like, what would be, can you state the analysis that you're looking for?
Well, I think in this case, there is no analysis.
No, I know that, but
would
so
warrant
I
that.
know that's your argument.
Yes.
So I want to imagine I'm the judge writing this afresh. How would you direct me to write it, to make that finding? What's missing?
Well, so for example, if an offender had offended against a child who was in another town, essentially, or if an offender had offended against strangers.
Well, those are examples of different kinds of crimes. I'm talking, is there any way that this person with these particular charges, is there any way to frame this in a way that would satisfy that burden, or is it just impossible based on the kind of offense this is?
So you're asking because it's a non-contact exhibitionism offense, yes. Well, I mean, we have a framework for assessing dangerousness for non-contact and specifically exhibitionist offenders. And that comes, if we look at, for example, well, the regulations require the hearing examiner to consider the level of physical contact, for example. And the regulations specifically state that tells us how dangerous an offender is. It's one of the things that tells us how dangerous someone is. Here, the hearing examiner didn't even mention that this was a non-contactive offense, but also the jurisprudence of this court indicates, provides us with a framework to assess dangerousness for this type of offense. In the Suave line of cases, what the court has said is someone like this might be sufficiently dangerous, even in the SDP context, if they engaged in luring behavior, cornering behavior, if they had followed a child, if they had targeted children, then someone like this, and if they had created a fear in the victim that they might...
And you're still looking for additional pieces of evidence based on the offender's behavior rather than the actual way the hearing examiner framed the analysis. You're looking for more than what this offender did in order to reach that level.
Yes, I think there would have to be more facts to support the dangerousness
So
findings.
it's not just that that finding is not written right or well enough.
No, it's not a technicality, it's not an issue of magic words. I mean, the hearing examiner has to engage in an analysis of the evidence. You know, the ultimate conclusions the hearing examiner reaches, or the critical inquiries, have to be tethered toward the subsidiary facts and findings that she makes. It has to make sense in light of the findings.
But she does all that here. That's where I'm confused. I thought you were making some kind of heightened requirement on the public dissemination, that there would need to be some kind of special extra analysis on that. Because we do go through all the factors, right? I mean, you may think it's not a great job, but he's a repeat offender with strangers, with at least one child. They go through all the factors, so that's where I get confused.
Well,
I thought you were requiring some kind of targeted explanation beyond what's done here, that anytime you have to say, okay, you're publicly distributing this information, you got to have a special category in your decision addressing that. Is that not what you're saying?
No, what I'm saying is that the hearing examiner actually has to make express findings as to their ultimate conclusions.
They do
And the
here,
ultimate
but they do
conclusions
here.
here are, what risk does he pose? Does he pose a degree of dangerousness such that this particular form of public notification is in the interest of public safety?
So you're saying exposing himself publicly is not dangerous?
Not in the way, you know, this is behavior that occurred in my client's home when he was alone, and the victim was looking out of her home in through the windows in his home. And I don't think that in the circumstances, the hearing examiner in this case credited the evidence that the neighbors were engaging in this behavior, and that there had been discussions with them indicating that there was something perhaps mutual going on here. And so the experts said, you know, this is very different from his exhibitionist behavior 20 years ago in the early 90s, where he was targeting strangers. You know, the typical exhibitionism is trying to create shock and alarm in the victim. That's not what was going on here. My client fully admitted that he used poor judgment, he made a mistake, he misconstrued the situation, he should not have engaged in his behavior. But it wasn't the same kind of conduct that he engaged in the early 90s. It was motivated by something very different.
Can I ask you on, I think what's difficult about this case, there are a lot of things, but one is the substantial evidence hurdle you have to, because the examiner does check all the boxes and makes findings, right? So there's still a substantial evidence deference we have to give. But can you give me a sense of some case law or something that would allow us to say that they didn't meet the mark on substantial evidence in this context?
Yes, I know in my brief I've cited a number of cases that discuss a hearing examiner's failure to meet the substantial evidence test. And it comes from Chapter 30A, Section 14.7, and this court actually has the authority to reverse the hearing examiner's decision where it's not supported by substantial evidence. And I think you asked earlier about the cherry picking of the
Right,
evidence.
and that's what I was going to get to. There seems to me to be a lot of discounting of the mitigation here.
Yes, I think it's the New Boston case is the case that I talk about in my brief, where essentially the hearing examiner here seems to give great weight to any negative evidence, which came mostly from the early 1990s, my client's really stale sex offense behavior. And she essentially overlooked a lot of the positive evidence about this case. And so, again, under substantial evidence, I think part of that analysis is also were the hearing examiner's finding of dangerousness adequate here. And of course, my first argument, which we've already addressed to some extent, is that they're not. But what happened is that when, Doe testified at this hearing at length, and the hearing examiner tended to credit anything he said that was against his interest. For example, he admitted that he engaged in exhibitionist behavior in the early 1990s, and he wasn't caught. And there's no other evidence. The government had no evidence of that before he said it. But he took his oath to tell the truth seriously, and he said, I did engage in it a number of times, 5 or 6 times, and I wasn't caught. And then there was a point in my life where I said, I'm going to stop this. His mother died of cancer. He said, I want to turn my life around. And he stopped engaging in this behavior. He went back to school. He built a really successful business. And he put that behavior behind him. And yet when he said something that was, I guess, in his favor, the hearing examiner disregarded that. For example, she disregarded his explanation, I guess, of his offending conduct, even though I believe it was really consistent with what he told the police, which was, I was triggered by the behavior that I saw across the street, and I realized my conduct was wrong. He also presented a lot of evidence from family members and friends showing that he has a lot of support and stability in the community. There was a lot of evidence about how hard he works. He works 80 hours a week. There was expert testimony that he poses no cognizable risk to reoffend, and that this recent behavior was really situational and arose from the rather odd circumstances in which he found himself in 2014. And yet the hearing examiner discredited the evidence from the multiple family members who testified and a friend who testified on his behalf. She discredited the evidence of his successful employment situation. She discredited the expert without a reasonable basis in the record. And so you see, I think it's in the New Boston case talks about, that the fact that the fact finder can't sort of, reject the evidence that doesn't fit the preconception that they have about this case and only give weight to that evidence that supports their preconception. And I think that's exactly what happened here.
If I could turn you to, is it your position that the degree of dangerousness must be moderate in order to justify internet dissemination?
Yes, Your Honor.
And do we know what the hearing officer meant when she said that it was not gravely, with language, I think, not gravely dangerous?
Yes, I mean, and my position is that the dangerousness findings here are inadequate, not only because of the circumstances of what my client did here, but she said he's not gravely dangerous, but she didn't say how dangerous he is, which is what she has to find. She didn't say that he is moderately dangerous. So I don't agree with the board's position that she's essentially saying he's not a level 3. And so.
Well, I take it gravely dangerous is a level 3, right? It's shorthand for a level 3, but it's level 3, right?
Well, she said he's not gravely dangerous. I'm not sure where in the statute it says that a level 3 is gravely dangerous. I'm not familiar with that. But I will say that the board's regulations require not only the statutory language we've talked about, but if you look at the regulations at 803 CMR 1.20, they require the hearing examiner to determine the risk of reoffense an offender poses, the degree of dangerousness as a function of the severity and extent of harm that will be caused if he reoffends, and then it says, in light of the foregoing, what level of public access is in the interest of public safety. So it's my position that in that way those elements are interwoven, because the finding as to what level of public notification is necessary has to be based on the foregoing, which is the level of dangerousness and the level of risk. But all of those things have to be assessed. And again, in the 20 to 25 page decision, the hearing examiner has to make, at a minimum, these ultimate findings and these critical inquiries.
So just trying to hone down what you're saying. You're saying that to justify internet dissemination,
Yes.
there must be a moderate risk of reoffense,
Yes, Your Honor.
and there must be a moderate degree of dangerousness defined essentially in the regs as if the person were to reoffend, what would be the severity and extent of harm that would arise from that reoffense?
Yes, Your Honor.
And in terms of moderateness, Am I correct that you're sort of viewing it among the panoply of sexual crimes that are within the scope of the statute? That is, as compared to rape or other kinds of contact offenses?
I'm sorry, I don't understand the last part of the question.
When you say moderate, I mean, the question is as compared to what? So I assume moderate
As compared to low or...
dangerousness, are you saying among the sexual crimes, in terms of the type of sexual conduct that we fear from a sex offender?
Yes.
That this would have to be in the moderate range of the extent and severity of harms that would be caused by a sexual offense?
Yes, exactly. And I think also that language in 1.20,
So does that mean an exhibitionist can never be a level 2 because it's a non-contact offense?
I don't know, I don't think so. And I think by analogy to the Suave line of cases, you know, this court said in those cases, we're not going to say there's no situation where a level 2, where a non-contact exhibitionist could be a sexually dangerous person, but we need to assess their dangerousness. We need to look at, did they target children? Did they lure children or lure someone? Did they engage in cornering behavior? And did they create a fear in a victim of a contact offense, a reasonable fear of a contact offense?
That's for the SDP stuff. That's a different world, right?
It is a different world, but it provides language and a framework for assessing dangerousness for this type of offense. And, you know, if you're asking whether, again, I'm not saying that there's never an exhibitionist, someone with an exhibitionist history who could pose a level 2 risk and danger and be posted on the internet. But certainly this case, but if the hearing examiner doesn't make these findings as to dangerousness, then we don't know why they determined internet dissemination was necessary. And their decision is basically, the most important component of their decision is immune from judicial review.
All right, thank you.
Thank you.
Mr. Bossy, good morning.
Good morning, Your Honors. May it please the Court, John Bossé for the Sex Offender Registry Board. In classifying the appellant as a Level 2 sex offender, the hearing examiner made adequate findings regarding the appellant's risk to reoffend and degree of dangerousness. Therefore, under the statute, the SORB is required to make the appellant's registry information publicly available, including by posting the information on SORB's
Let me stop you there.
website.
What was her finding? She is required under CMR 1.20 paren 2 to determine the offender's dangerousness as a function of the severity and extent of harm, blah, blah, blah. From my review of it, the only finding she made of dangerousness is that it was not gravely dangerous, is that the offenses were not gravely dangerous. Is that correct?
That is not correct, Your Honor. The hearing examiner
Point to me to where the hearing officer made her determination regarding dangerousness as required by the reg.
Yes, Your Honor. The hearing examiner made findings with regard to both risk to reoffend and degree of dangerousness by applying the regulatory factors specifically designed to determine risk to reoffend and degree of dangerousness. And this is her duty under the statute.
Right, but she's required to make, I'm just reading the reg.
Right.
She is required to determine the offender's risk of reoffense, which she determined to be moderate. Then she's required to determine the offender's dangerousness as a function of the severity and extent of harm the offender would present to the public in the event of reoffense. And I'm asking you, I know she reviewed the factors, but the only thing I can find in which she made a determination as to dangerousness, as required by the reg, is that I forget whether it said the person or the crimes were not gravely dangerous.
But that's correct. So when she stated that the offenses were not so gravely dangerous, she was implying that this individual should not be a level 3. But in discussing his offenses, she stated that the public deserves access to his registry information, including by publishing the information on SORB's website.
Wasn't the dangerousness that the registrations needed to alert potential neighbors to keep their shades up, essentially?
That's correct.
That's her finding.
That's her finding, that neighbors present and future, because of his exhibitionist conduct from 1989 through 2014 deserve.
But that's the only, and I looked as the chief did, and I'm trying to find the dangerousness, but that's the only thing I could find that's close to the dangerousness finding, right? And that's it.
Right, but it was also implicit that he's a moderate degree of dangerousness because.
Well, it's kind of circular, though. If you say it's implicit because she found he was a level 2, then of course he has to be moderate, but we still need a finding.
Not necessarily. As long as the examiner applies the regulatory factors to the facts of the case and comes to a conclusion that the individual should be a level 2, there's nowhere in the statute that they have to make an explicit finding of risk to reoffend and degree of dangerousness. In this case,
On those factors, is there some degree of cherry picking that goes on? Because when the hearing examiner assesses stability, for instance, this person has 3 homes, a business, family. The hearing examiner says, well, he might have all this stuff, but he reoffended. So she discounts stability. But everybody that's in front of the board has reoffended. So isn't this a little circular? You know, he's offense-free for 15 years, and she kind of discounts that. There's expert testimony. She says, well, but the expert knows him and has been treating this person, so as opposed to a hired gun, so we're not going to discount that. How do you address this cherry-picking issue?
well, I wouldn't discuss it as cherry picking, Justice Gaziano.
Well, I hope you wouldn't, but how do you address it?
She appropriately reviewed the facts of the case and applied the factors, and it's not that she didn't give him any weight towards certain factors such as his age, such as sex offender treatment, and the stability and the support that he has from his family. She just properly noted that, for example, for age, 50 is the point which is considered advanced age for sex offenders, that their sex drive begins to go down. But she properly noted that he committed his last offense of open and grossness at the age of 50, and at the time of the classification hearing, he was only 52. With regard to sex offender treatment, that's also another mitigating fact, that if the individual participates in sex offender treatment, that can have a correlation to less risk to sexually reoffend. But she noted that in 2007, he engaged in sex offender treatment, and it didn't prevent him from reoffending in 2014. And there was testimony at the classification hearing that the therapist who treated him in 2007 thought his behavior was caused by an impulse disorder. Here, the new therapist could only explain his behavior as being poor judgment. And same with the offender, he could only explain his behavior as poor judgment. But yet, this is an individual who was 50 years old at the time of the offending, operates a successful commercial business, has 3 homes, and can only explain his behavior as poor judgment.
Mr. Bossi, let me pick up on your point about the implicit finding that the degree of dangerousness is at least moderate, and your point that the statute doesn't require more than that. Assume for the moment it doesn't. The amicus brief makes the point that in order for this statute not to offend substantive due process, the finding really of dangerousness needs to be explicit. The regulatory factors, the definition of dangerousness, it needs to be explicit so that there's not a risk of overclassification. What's your response to that?
My response to it is that the plain language of 178K 1 and 2 does not require that the finding be explicit. So long as the examiner, right.
Let's assume that interpretation is absolutely correct.
Mm-hmm.
The question is whether or not, without an explicit finding of dangerousness based on regulatory factors and a specific definition or definitions of dangerousness, if you don't have that, there's a risk of overclassification that rises to the level of substantive due process. So even if the statute's constitutional, the point that I'm asking about, that's raised in the amicus brief, is it nonetheless a constitutional violation?
And I don't believe that they have a constitutional right to an explicit finding of both risk to reoffend and degree of dangerousness. What they have a right to is a decision decided by an impartial hearing examiner, and that the hearing examiner make detailed findings with regard to the facts of the case, as well as detailed findings with respect to the statutory and regulatory factors that apply to the case.
Right, but what they also have a right to, under the Constitution, is not to be overclassified.
Right. And so as long as there's substantial evidence to support the hearing examiner's ultimate conclusion, then the offender's procedural due process rights were protected throughout the classification hearing.
So are you saying then that any second-level offender is automatically eligible and automatically gets internet publication? There's no need for additional findings?
That's correct. There's no need for an express finding of dissemination, including internet publication.
But I'm not asking about procedural due process, I'm asking about substantive due process.
Okay.
And there's a risk of overclassification. There's always a risk of overclassification, and that risk is mitigated if there's explicit findings based on regulatory factors and definition of dangerousness. And does that concern of not having an explicit finding rise to the level of substantive due process?
I do not believe so, because so long as there's adequate support for the findings that the hearing examiner finds, as well as the factors that she applies based upon the facts.
Is it your view that you can have internet dissemination when the level of dangerous is less than moderate?
No, you need clear and convincing evidence that the offender poses a moderate risk to reoffend and a moderate degree of dangerousness. That is what the statute requires.
And where do we, all that I can find is in the last paragraph, I acknowledge that his offenses are not gravely dangerous. They are quite upsetting to his multiple victims. Is that, in your mind, a finding that this falls within the category of moderate dangerousness?
It's not only that finding, but it's the hearing examiner's analysis in the previous pages in which she applies the facts of the case to the regulatory factors.
Right, but
And there's,
you
and
have
there's,
to.
and there's ample support for those factors. And as a result, there's clear and convincing evidence that this individual should be classified as a level 2.
But doesn't the regulation require certain determinations? It requires 3 determinations, does it not? Requires the hearing examiner shall consider the relevant and credible evidence and reasonable inferences derived therefrom to determine, 1, the offender's risk of reoffense. She's done that. 2, the offender's dangerousness. I'm still asking you, where has she, I know that she went through all the various factors, but you do that and then you say, based on all of this, I come to the conclusion that the level of danger is something. That's where I don't.
Well, she not only discusses his dangerousness by applying the regulatory factors, but in that final paragraph, she discusses his dangerousness when saying he's not gravely dangerous, meaning that he's not at level 3, but because of his conduct between 1989 to 2014, the public deserves awareness of his conduct, and as a result, he should be published on SORB's website.
And let me follow up. She seemed to think that there would be some special efficacy here from publication. If it were to be published, what information would be published?
Well, his name, date of birth, the type of offense that he was convicted of, his address, residential address. If he has a secondary address in Massachusetts, that would be published. If he has a work address, that would be published.
And where, from that information, would a neighbor understand that that means that they should keep their shades down and not undress with the shades open, which is what her finding was. Her finding was that if they knew this, they would know they should be careful when they undress, because that's a trigger for this particular behavior. Where in the internet dissemination would anything have been disclosed as to what the trigger was for his lewd and lascivious behavior?
There's no information on the website other than the offense, open and gross lewdness.
So what is the rationality of her finding that had his neighbors known of his sex offender history, they might have been more modest in the rooms facing his home? How would they know that unless they knew that their behavior would be a trigger for the defendant's behavior?
I'm not too sure.
Go ahead.
What do we make of the hearing examiner's failure to address the level of contact of the offense in a non-contact offense?
So the regulations, a lot of the factors don't discuss the difference between contact and non-contact offenders. They simply apply regardless if the individual is a contact offender or non-contact.
Factor 19 does.
Factor 19 does.
Okay, and it's not addressed.
It's not addressed because this court previously stated in 2006 that mitigating factors that aren't applicable do not lower one's risk to reoffend.
That are not applicable?
That are not applicable. So, for example, just because...
How is non-contact non-applicable in this case?
How is it?
You're saying that non-contact was not applicable, so you didn't have to address this? Wasn't this a non-contact? Let's start from the beginning. Was this a non-contact offense?
Yes, it was a history of exhibitionism.
All right, so that's a non-contact offense.
Mm-hmm.
There's a factor that says level of contact of the offense,
Right.
right? And that could be a mitigating factor?
No, that is a risk elevating factor. And previously in 2006, this court stated that if factors are inapplicable, the offender does not receive mitigating weight for that. So, for example, Factor 10 addresses general criminality. And if the offender has a history of just engaging in sex offenses but has no other criminal record, they don't receive mitigation for that.
Okay, so if it was a rape, a contact offense, it can be an aggravating, but you're saying because it's not a contact offense, it can't be a mitigating.
Correct. That's correct, Your Honor.
But wouldn't that bear on the level of dangerousness?
The fact that this individual is an exhibitionist is still relevant to dangerousness because of the emotional harm that it causes to victims. Just because this is a non-contact offense doesn't mean that it's a victimless offense, and that is supported in the administrative record. For example, in 1996, while at a train station, the reporting party had to run away from the appellant because he approached her while touching his genitalia, and she told the police that she ran in fear. In 2014, the appellant knew that he was residing next to a family with a teenage female. She explained his conduct as being disturbing and causing her great anxiety. So we have to look at the emotional harm that exhibitionists cause to the victims, and that's why the public...
Is there shelf life on offense-free? On offense-free, is there a time period we would have to look at?
That's correct. So Factor 29 addresses offense-free time in the community.
Right.
And they state that if the individual has been in the community 5 to 10 years, that lowers risk to reoffend. If they've been in the community more than 10 years, that substantially lowers a risk to reoffend.
Okay, so here we had 15 years, right?
We have 15 years. So between 96 and 2014,
between really the public acts and the acts in the House. We had 15 years.
But he also had the treatment in 2007 that did not prevent him from engaging in the subsequent behavior in 2014.
Okay, thank you.
Your Honor, thank you.